So good afternoon, everyone, and welcome to this last sales lunchtime seminar of the year. It gives me very great pleasure to welcome our speaker today, Dr. Bernadette Zelger, who is an assistant professor at the University of Innsbruck. Dr. Zelger is a graduate of that university, but she also holds a diploma in competition law from King's College London, and also an LLM, also a specialization in competition law from Queen Mary, University of London. She worked for a time in private practice, and then she moved to academia, and she has published very widely in a range of top journals and has received awards both nationally and internationally for her research. More recently, the Antitrust Writing Award, which is a very prestigious award in the field of competition law. But her profile is by no means limited to competition law. She works across several areas within the spectrum of EU law, internal market, state aid, of course, competition, and more recently, EU constitutional law. So I am absolutely delighted to welcome her today, and she's going to talk about this very suggestive title, The Future of the European Union, Socio-Economic and Political Challenges in its Legal Constitutional Framework. So without any further delay, let me leave the floor to Dr. Zelger. Thank you.
So many thanks, Albertina, for the kind introduction and for the opportunity to talk here today. I want to structure my talk into 3 parts. In the first part, I'll briefly map out how I came to dig into this very, or admittedly, very broad topic. In part 2, I want to draw what I'd call the bigger picture, against which I'll narrow the scope of my analysis down to the law, its role and its effects. So in that sense, part 2 forms my problem analysis. And in part 3, I'll take it from there and shed light on the possible future scenarios I see with respect to shaping the EU legal constitutional framework, not only to make it work for the better, but also to basically counterbalance the identified challenges or counterbalance the identified root of the challenges we're facing today. So how came I started digging into this topic? The aim to understand what was or is politically, socially, but also economically going on in the democracies of our so-called Western world, let me engage with a topic or with various different topics that soon turned out to go beyond what my classical doctrinal work as a jurist looked like. So after having graduated from my undergrad with my diploma in law in Innsbruck, I've what I'd call pursued a career that is a prime example for a Erasmus generation career. I've lived, studied, and worked in many different European, but also other cities and capitals around the world. And I've met many like-minded persons along this way and in all these stages. However, coming from a rather small alpine town, and you can see it on the slide in the midst of the Alps, whenever I visited home, I met people who thought or are still thinking very differently about the European Union and therefore about the project I myself have very much profited from. So talking to these people, I can tell or I sense that they felt alienated, and for them, Brussels was just very far away. They felt somehow left alone with their daily challenges of life, be it skyrocketing housing or living costs or inflation. Retrospectively, I think I could have met people thinking along these lines during my time in London, which was pre-Brexit, if I'd left London a bit more often than I actually did. And I think I probably would have met people thinking along these lines if I'd left the EU bubble in Brussels during my time living in Brussels, and as it's even called by those living within the bubble, a bit more often than I actually did. Moreover, not only once have I engaged in discussions with people thinking differently. And I've tried to convince them of how I see the European Union, what overall good it brought, what increase of welfare, prosperity for everyone, mobility that was possible. Unfortunately, I think my endeavor to convince them wasn't very successful, and I brought a couple of quotes that somehow that convey the sentiments that I faced in these discussions. So I fear that I wasn't successful in eliminating people's skepticism and alienation. And I didn't convince them with respect to the problem people see in, and I quote, people with money from other European countries buying land and apartments that were ultimately driving up prices. It didn't help in maintaining local skiing passes, which are in clear breach with EU anti-discrimination law. And it did not really mitigate the problem they see in, I quote, too many medical students from Germany for whom Austrian taxpayers pay education before they go back to practice in Germany. And on a side note, Germany has the numerus clausus. So this is why many people from Germany come to Austria to study medicine. And Austria is facing a lack of doctors, particularly in rural areas. And a last quote, running in a very similar vein as I think my first one, it didn't change people's perspective on the issue they see in foreign students, which too, quote, drive up real estate prices and rents, unquote. So, while my perception of the European Union has always been a very different one, and while I did not really like what I heard in all these discussions in skiing huts, traditional restaurants, beer gardens, etc., at one point, what I could relate to, or what I couldn't neglect, is the fact that, well, their experience and what they told me, what they shared with me, was not linked to economic integration at all. So I couldn't exclude that there was one link or another to trade liberalization. And while I knew it wasn't the European Union to blame for all this, at least not only, I started wondering or asking myself, well, what role had it played? Had it, one way or another, contributed, and if so, in which way, to the socio-economic and political challenges we're facing today? And if so, putting on my lawyer's hat, what role had the law played in all this? So this was basically the starting point of digging into this very broad topic. One disclaimer or one caveat up front, it's ongoing research. So not all strands of my argument might be fully fleshed yet. So bear with me. But having said this, I'll start with what I'd call the problem analysis. And it's important to emphasize at the beginning that I employ an approach to the law that I'd call a constructivist approach, drawing basically from political philosophy, particularly Rawls. What do I mean by a constructivist approach? Law provides the rules that governs our economic sphere, and it provides the rules that govern our political sphere, and it provides the rules that govern the balance between the market and the social. And in doing so, I tried to identify 4 different dimensions that are inextricably linked and that have reciprocal effects on each other. And I'll start with the political dimension. And as elaborated on in the abstract by which this workshop today was announced, I think there is no doubt that there is a swing towards populism and populist parties all across Europe. In Europe, particularly to the far right, in Southern Europe, radical left, Greece and Portugal, if I'm not mistaken. But the tendency we see is a swing or is a rise of populism. And at a global scale, in the global north, this phenomenon of a rise of populism is not limited to the European Union. I think there is no need to mention Donald Trump in this regard. But be that as it may, the reasons for populism in political science literature have most often been explained by so-called exclusive cultural defense reflex. So something where people are opposing migration, etc. However, I would argue that most recently, an alternative explanation to the rise of populism has gained in attraction. And according to this latter view, the reason for the rise of populism lies with the political economy of a state or a political entity. So basically the socio-economic reality people are facing. Danny Roderick, a Harvard economist and Nobel Prize laureate, has argued in this vein. And Philipp Manu, a political scientist from Germany, the University of Siegen, provided vast empirical data for the European Union supporting this claim. So, in simple words, populism stems or has its roots in the socio-economic reality people are facing. And as Danny Roderick puts it in a global context, he argues that the rise of populism is the symptom of a protest against the effects of globalization. And if we think about what is the main engine of globalization, I would argue it's trade liberalization. Which brings me to the economic dimension. And I'll get back to the legal bits in a minute. And the economic dimension, or the socio-economic dimension, is particularly interesting because, as we all know, the European Union is heavily based on the idea of economic integration. And I'd like to start again with two quotes. As noted by Professor Mervyn King, professor at LSE, and I quote, "What economists and others overlooked was the fact that although potentially trade can make everyone better off, that doesn't agree that it will make everyone better off." Or, as Danny Roderick puts it, a Harvard economist and Nobel Prize laureate, "Trade generically produces losers. So, the result that openness of trade creates losers is not a special case." In other words, liberalization, trade liberalization, always has distributional implications. And in that sense, I would argue that the widespread narrative that trade liberalization brings prosperity and increases overall welfare for everyone doesn't do justice to the complexity of what trade economics actually tell us about the effects of trade liberalization. I think it's important to emphasize that the overall good of trade liberalization depends on a very narrow set of assumptions. And I forgot the name of the economist that proved in a series of papers that if you deviate very slightly from the given assumptions, the overall balance between, or the overall benefit might tip, and there might be an overall negative effect of trade liberalization. This is why in economic theory, or when you look into papers and research on liberalism, there is one line that argues that when creating markets, you need market complementing or market correcting provisions or policies in order to strike a balance between market making, creating provisions and policies, and market correcting or complementing policies. One could capture these two areas by the two notions, market and social. European lawyers in this room know that I'm referring to Sasha Garvin and EU literature in this regard. But this is an important thing, I think, to acknowledge. And this form of liberalism, which has been called by the notion of embedded liberalism in a seminal paper in the 80s by the political scientist Rugi, has arguably existed in the time after the Second World War up until the late 70s. And it's been replaced by a more neoliberal agenda that puts more emphasis, simply speaking, on the market. And having said this, I'll continue to briefly elaborate on the legal constitutional dimension. I think there is no doubt, and most of you, as I understand it, are lawyers, that there is an imbalance between market and the social enshrined in the EU treaties. This is owed to political will back in the days, the willingness to integrate economically was there, but there was no will to create a real social Europe, etc. I mean, this can be traced in history quite well. And this imbalance enshrined in the treaties that is characterized by hard competences in the economic or market sphere, namely by means of the market freedoms and the competition provisions, and by soft power or coordination mechanism in the social sphere, namely the open method of cooperation, the social dialogue, the European semester. So mechanisms that strive for coordination and convergence while acknowledging the diversity of national social security systems is weak, if you will. And this imbalance is also echoed in the case law of the European Court of Justice. It is echoed particularly, as one example, in the trade liberalization jurisprudence of the court, where the court has established, and I don't want to carry calls to Newcastle, but just to briefly sum this up, it established a very broad notion of what constitutes a restriction. So almost any measure falls within the ambit and constitutes a breach of the free movement rules. So many measures, policy measures that are adopted at member state level are only declared compatible with European Union law at the justification proportionality level. So to sum these three dimensions up, or to, in a nutshell, what do I want to say? I want to say that we have an imbalance between the market and the social, enshrined in the treaties, continued and found in the case law of the court. This imbalance between the market and the social creates a socio-economic reality where social policy is somehow detached from economic policy. And this provides fertile ground for political developments that we might call populist. So this is the link or the argument that I'm trying to make. Meanwhile, or at the same time, and this is the democratic institutional dimension that is somehow crucial in this overall picture too, the ways of the European legislator are limited in correcting the case law of the European Court of Justice. Why so? Because the market provisions, the fundamental freedoms, as well as the competition provisions, are found at the constitutional levels. And these provisions are, in a nation-state setting, usually found at the level of ordinary laws. And the fact that we found these provisions at the constitutional level is what Grimm called over-constitutionalization of the EU treaties. So in order to correct the court, you need treaty change, you need anonymity. And this is what makes it quite hard for the European legislator to correct the case law and the jurisprudence of the court. At the same time, we have national legislators who could adopt policy measures as well, that have no standing at all to correct the court. They have to abide or obey the jurisprudence and the case law. So a lot about, from an institutional perspective, it's a lot about what can the court do and how powerful is the legislator, or in the European multi-level governance system, the legislators. And I would argue that the effects, the overall effects of the case law that basically stem from the constitutional framework are very powerful when it comes to shaping the socio-economic dimension, the competence dimension, and I'll elaborate on this a bit more extensively with my next slide. And these two dimensions that are shaped powerfully by the case law of the court, they have political implications, as I tried to show in the circle on my very first slide. Juxtaposed to these very powerful effects of the law, we have rather, I don't like the notion, or I don't like the term weak, but we have rather weak legislators, because the system they have to operate within is a bit rigid in the sense that you need anonymity for treaty change. This is very different to constitute the relationship between a constitutional or Supreme Court at the national level and a national legislator. You never have anonymity. You usually have a qualified majority to change a constitution, but not anonymity. And as I said, national legislators are limited in their policy leeway by means of the court's doctrine, because this very broad notion of what constitutes a restriction interferes with the policy leeway of the member state, and it limits the policy leeway. And it can't correct the court, because a national member state legislator is not in a position to correct the European Court of Justice in any case. So, a bit more on the effects and what I mean by the powerful effects of the law shape, particularly the socio-economic dimension. Let me start with the level or the relationship between the European Court of Justice and the EU legislator. We all know that the European Court of Justice has a monopoly in interpreting the EU treaties. And in that sense, it rules on competence issues. And if we look at the competence jurisprudence of the European Court of Justice, one could claim that it's a rather competence-friendly jurisprudence the court has developed over the years. Hardly any secondary law measure is ever declared void by the court. And this competence-friendly jurisprudence, or inherent to this competence-friendly jurisprudence, is a fostering of economic integration measures. Why so? Take, for example, Article 114 TFEU. It's been interpreted extensively, and by means of being very generous with respect to measures that can be adopted on the basis of Article 114, this has an indirect effect on the socio-economic dimension too, because this emphasis on the market, on the economic sphere, is enhanced, further strengthened. Let's see whether the court will be as competence-friendly as it is in the market sphere, also in the social sphere. I mean, there is currently a case pending that concerns the Minimum Wages Directive, where Denmark brought a challenge. And if I remember correctly, the Advocate General advised to declare the directive void. So let's see what the court is going to say. But in any case, the competence-friendly jurisprudence kind of strengthens the emphasis on the market, and this has an indirect effect on the socio-economic dimension. The second relationship or sphere or dimension I want to briefly shed light on is the relationship between the European Court of Justice and national legislators. I've already mentioned the market jurisprudence of the court with the very broad notion of what constitutes a restriction, and the fact that almost any measure is captured and can be declared at the justification proportionality level only. This is already shaping or continuing the imbalance between the market and the social. And interestingly, while shaping the socio-economic dimension, it has an indirect effect on the competence dimension. Why? Because it undermines or it interferes with policy leeways of the national legislator that actually remained within their competencies. So the phenomenon of competence creep, this is one layer to this phenomenon. And by means of these effects that shape the socioeconomic dimension, but at the same time the competence dimension and vice versa, one could claim that the law, the case law particularly, is quite powerful. And when you look at the very left of the slide, I have and the yellow-blue section, or however you want to call this part on the slide, I have another phenomenon depicted there that, in my view, supports the claim that the case law is powerful in its effects. And it's the judicial dialogues we observe between national supreme or constitutional courts and the European Court of Justice. These cases usually concern competence issues, so-called ultra-virus cases, and constitutional or supreme courts are basically, loosely speaking, telling the ECJ, well, don't go too far, don't overdo it. And this is not to prove the powerful effects of the case law, no, but it's a symptom of the fact that the case law is powerful. At least this is what I would argue. So this brings me to claim that in shaping the EU legal constitutional framework, the case law has a powerful effect on shaping the socioeconomic dimension. It has a powerful effect on shaping the competence dimension. And they have reciprocal effects on each other. And doing so, they bring political implications. As I said, we have the imbalance. The imbalance creates a socioeconomic reality, and this socioeconomic reality is fertile ground for political developments, populist developments, as we observe today. So in a nutshell, what is the status quo, and what issue do we have to solve in order to make the system work to the better? The status quo is an internal market with uniform rules. We all know that. On the other hand, we have a very, what I would argue, a rather fragmented Europe, where we have mechanisms in place where we try to converge and to coordinate social policy measures. However, we do acknowledge the diversity of national systems. Interestingly, and I mean, the paper I found that said so is from 2012, but obviously in the area of the social, so in the social sphere, there are only approximately 70 directives, secondary law acts or pieces that strive for harmonization or coordination in this regard. And this, I mean, I don't know how many acts we have in the market economic sphere, but I'm quite sure that it's more than 70. So it's an old figure in the sense that it's more than 10 years ago, but it's quite telling, I would say. So, and while we do have these soft mechanisms, coordination mechanisms like the open method of cooperation, European social pillar, etc., I think this doesn't change the fact that Europe is still fragmented in the social sphere. And this is accompanied by the fact that we have not only the social security systems are fragmented, but all systems that are somehow linked to the social sphere, like tax, education systems, health systems, etc. Furthermore, we have, when looking at Europe or the European Union, different forms of welfare states. When we take the forms of welfare states that have been developed by Asping Anderson already in the 90s, it's the welfare state of the Scandinavian countries, which is a very extensive welfare state, is different from the Austrian-German Sozialstaat. And that is, again, very different from the Anglo-Saxon-inspired, very liberal market economies in Eastern Europe. So there is just a variety of different forms of welfare states. And at the same time, the welfare levels are diverse too. I mean, compare the welfare level of Austria with the one in Croatia and with the one in Sweden. It's just very diverse systems. So this kind of imbalance between the market and the social that is fostered by the powerful effects of the case law that I tried to map out in this talk by means of the competence-friendly jurisprudence and the trade liberalization is the status quo we're dealing with. And this is accompanied by a democratic institutional dimension where the EU legislator is limited or has a limited capability of correcting the court. So if we agreed on my problem analysis that we have the imbalance and a lot of phenomena are basically a corollary of this imbalance, what we would need to do is restore the balance. So create a genuine equilibrium between market economic policy and social policy, market making, creating provisions and policies, and complementing and correcting policies and provisions. So how could we do that? I think there are two scenarios, and I'm happy to hear if you have any other scenarios in mind how we could take it from here. But those are the two I can identify, or I was able to identify for the moment. And the first one is treaty change. Let's integrate politically. Let's transfer competences from the member states to the European Union level. And then let's catch up with integration. I think important to emphasize in this regard is that catching up with economic integration that has been ongoing for more than 70 years is a tremendous undertaking that won't happen from one day to the other. So this might take time. During that time, we should probably introduce a stalemate, or at least not foster economic integration in order to increase the gap, but we should catch up with social integration. On a side note on treaty change, and this is, I think, important to say in order to consider the institutional dimension, I think treaty change shouldn't focus on the institutional dimension only. What do I mean by that? I think we won't eliminate the democratic deficit, as an example, by further strengthening the parliament only. I think we should be very much aware and take account of the effects, powerful effects in my view, that I've tried to illustrate in this talk. And they can be captured by over-constitutionalization and competence creep. Moreover, taking scenario one to a reality check. Is there political will? Because, I mean, if we give up on sovereignty, there must be political willingness to do so. And to be frank with you, I don't see that for the time being. Feasibility brings me back to what I elaborated on a couple of minutes ago when it comes to the different forms of welfare states and the different levels of welfare services. It goes beyond my expertise to assess whether it's actually feasible or not. It might be feasible, but again, I think it's a tremendous exercise and it might take a while. So what about scenario two? So what other options do we have, particularly in light of the current political circumstances where the willingness to give up on sovereignty doesn't seem to be very big? A refinement of the case law. What do I mean by that? I've briefly elaborated on the broad notion of what constitutes a restriction, and that most measures are declared compatible at the justification proportionality level only. And if we developed an approach to the law that pays deference to the division of competences in the multi-level system, I think one could also allow measures that accompany or that counterbalance or that restore the balance in the social sphere. Admittedly, this would more often happen at the member state level. At the same time, however, we could keep on converging and coordinating our social security systems and social policy. So as in scenario 1, this would kind of be another way to restore the balance between the market and the social. Hopefully, if you restore the balance between the market and the social, the politically tense situation might abate. I mean, hopefully, if the claim I make with my slide, if the claim I make with my first slide, so that this is all somehow linked together, this should basically abate and lead to a more relaxed political situation. And maybe such abated political situation would pave the way and increase the willingness to give up on sovereignty, so pave the way for scenario 1. So in a nutshell, I think these two scenarios can be captured by two questions. It's about whether we want to make one step forward in order to maybe or live with the threat that we're going to make 5 steps back. Or shall we make one step back or non-step back, no forward, in order to make 5 steps forward? Many thanks for your attention, and I'm looking forward to discussion and debate.